and go.
Thank you very much. Good afternoon, everyone, and welcome to the Public Safety Committee. We have one item on our agenda today, and that's to discuss Bill 1821, which is Police Internal Affairs, Procedures and Reporting Requirements. We have had one previous work session on this, and we've come up with some amendments, I think 4 amendments, and we still have 4 outstanding issues for discussion. And it is my hope, if the committee will go along with that, to actually vote this out of the committee today. So with that, before we begin, let me ask the committee members, President Hucker or Vice President Albernaz, whether they have any statements before we turn to Ms. Wellens, who has done an outstanding job once again for doing the packet.
Thank you, Mr. Chairman. I'm really glad we're returning to this issue. I wish we didn't have to, but of course, all of us were alarmed by the horrible incident in January 2020 involving a couple of our officers and the 5-year-old boy at East Silver Spring Elementary School. This bill was drafted sort of as a response to that and to some identified gaps that I think emerged from that discussion that came to our attention regarding our body-worn camera policy. I think the bill has been drawn up with the input of a lot of stakeholders on every side to increase community police trust and confidence following that incident, make sure we have more appropriate transparency and oversight of our body-worn camera policy. Thank you.
Thank you. Vice President Albernaz, did you have any? No, we're good. Very good. When we will begin, Ms. Wellens, if you could please, I guess, lead us through where we've been, quickly lead us through that, and then get us to where the 4 outstanding, I believe it's 4 outstanding issues that we should be discussing, and then we can vote this out, please.
Yes, thank you, Mr. Chair, and good afternoon to you and the Council President, Vice President, and Chief and Assistant Chiefs, and Ms. Roberts. As you noted, there was a prior work session on Bill 1821 at which the committee adopted several amendments, and there are about 4 outstanding issues. The first 2 were specific. The Public Safety Committee specifically asked staff and police department to follow up on. One quite outstanding question was who within the police department should be conducting the random review of body-worn camera footage. And in addition, the other big issue that was outstanding as of the last work session was whether the Internal Affairs Division should review all complaints against officers that fall into certain categories, whether this bill should mandate that, regardless of the source of complaint, or as the bill is currently written, should it remain that that IAD would be under this bill reviewing just certain types of incidents that were discovered through the random review that's mandated under the bill, and then other types of complaints would be investigated pursuant to existing police policies. So, and then there are a couple other additional issues at the end that were issues that advocates had previously brought up and have reiterated that staff wanted to bring to the committee's attention. So without further ado, the first issue of who should conduct the random review of body-worn camera footage, and I'm on page 5 of the staff memorandum. The U.S. Department of Justice indicated in its standards and guidelines for internal affairs that an agency's internal audit unit, rather than the officer's direct chain of command, should periodically conduct a random review of body-worn camera footage to monitor compliance with the program and assess overall officer performance. And similarly, Chief Jones has indicated that, the relatively newly developed Professional Accountability Division of our police department should be the division to conduct these audits. He noted that the division was created in 2020 to oversee compliance with established policies, procedures, and legal mandates. So I think this professional accountability division would be akin to the audit unit that's recommended by the U.S. Department of Justice. And along those lines, there's a potential amendment for the committee's consideration that would identify the professional accountability division as the one to conduct periodic random reviews of body-worn camera recordings.
Thank you. And I'm going to turn to the chief. This division started in 2020. So have they, how much work have they actually gotten to do at this point? I mean,
so they have an incredible lot of work to do. They have been responsible for compliance for our department in a variety of different ways. One is, as we are CALEA accredited, the police department nationally accredited, they are responsible for overseeing that accreditation process. But they're also, as importantly, responsible for conducting audits and inspections of all of our personnel, our processes such as our evidence unit, our crime lab, our police officers' equipment, inspection as relates to that, as well as overseeing the body-worn camera compliance program to make sure that officers are compliant with the protocols, our required mandates in our policy as to the use of body-worn camera. So there are checks and balances from there. So the Professional Accountability Division is very busy, and I believe that this fits right into their when we look at compliance and auditing of any of such a what is requested in this bill. They would be the quintessential division to actually handle that. I would note to the committee that the Internal Affairs Division is the administrative investigative unit for our department. As you noted, that the council provided 2 additional positions for Internal Affairs, specifically for the workload that they have been tasked with in order to have shorter time frames of turnaround for cases to be completed. If we were to add this component to their workload, it would slow that down and would be counterproductive to what the council provided for those positions. So that is why I also made the recommendation that this be placed under the view of the Professional Accountability Division, which operates directly under the Office of the Chief.
Chief, I think you make some very, very valid points, not just on this topic, but on many others. I personally am in favor of doing it just the way that you have suggested, to have it under the Professional Accountability Division. I don't know where my colleagues are on this one. President Hucker, Vice President Alvarez, where are you on this topic?
I think that makes a good amount of sense. Is it also, Chief, do you feel like it's any more sort of objective to keep it in the Professional Accountability Division, so there's not sort of an effort, as the DOJ said, to undermine the trust between an office and his or her immediate supervisor?
Yeah, I think it would be more productive by doing it that way, because it doesn't necessarily have any action with the actual supervisor who's actually making a judgment call on their own personnel. It's actually the Professional Accountability Division will look at it from a different perspective, and also to just really have looking at the policy and procedures that are in place. And then if they see that there's an issue, they then would make that referral to the Internal Affairs Division for an administrative hearing if they see that there is something that they believe is a violation of policy.
So it's sort of a second set of eyes.
Exactly.
And then regardless of the outcome, the officer can go back to work without feeling like, their supervisor that day just ruled against them last
Absolutely.
Friday.
Absolutely.
Okay.
Yes.
All right. I get it. Thank you.
Vice President Alvarez, do you have a thought on this one?
I agree with the chief's recommendation as well.
Okay, so that's a 3-0, Ms. Wellens on that one.
Thank you, Mr. Chair. Issue number 2 begins at the bottom of page 6 of the staff memorandum. And this relates to the scope of what IAD must investigate. And under the bill as drafted, IAD must investigate certain types of serious types of complaints that are identified through the random review of body-worn camera. Some advocates, the Silver Spring Justice Coalition, has suggested that this should be broadened so that the IAD must review those certain types of serious offenses regardless of the source of the complaint or how the complaint was discovered. So the reason this gets complicated is because, of course, current MCPD policy already sets forth, what the IAD does and when it investigates. And in particular, you can see under Functional Code 301, as is explained on pages 6 and 7 of the staff memo, there are certain incidents, for example, use of firearms, or when an employee is charged with a criminal offense, that have to be referred to IAD, that IAD has to be made aware of them. And then the policy states that IAD has primary responsibility to investigate certain types of complaints, including use of force complaints and others. So really the only concern, I think, about, or at least from the concern, not from a resources or policy matter, but the concern just kind of legally of saying that they must investigate all of those types of complaints, is that the policy says they have primary responsibility, whereas if you adopted that amendment, we'll be saying that they must investigate each one of those types of incidents. So, and I apologize, Mr. Chair, this is a little bit in real time, but I was discussing with Ms. Roberts ahead of time, perhaps one way to address this would be if under subsection D of the bill, if we just said the Internal Affairs Division must have primary responsibility to investigate, in addition to any matter it is required to investigate by the chief or under department policy, any body-worn camera recording identified under subsection C, that's the random review, or related to a complaint against an officer, that, and then you could list the subsequent particular serious types of potential offenses, the use of force, the involvement of a child, potential criminal offense, etc. So that's a slight modification that staff would suggest for your consideration. If you want to expand what IAD is doing under this bill, but want to keep it consistent with what they're already doing under existing policy, but to kind of codify that. And then, not to confuse things further, but one other point that, and I may need to rely on Ms. Roberts here, but she pointed out that one of these items that IAD has primary responsibility for looking into is potential criminal offense. And it should be clarified there, just, as a matter of, reflecting the reality and the needs of the department. It should be indicated there that a criminal offense, the IAD might not have primary responsibility to investigate a criminal offense. It's that they would have primary responsibility to investigate an administrative conduct issue in connection with the criminal offense. So we should probably add language there to clarify that.
Right. On the second part, it makes a lot of sense, and it's really for clarification rather than for anything else that we're doing. On the first part, on the first suggestion or thought that you had given, could you read that one more time, please?
Yes. Yes, Mr. Chair. So it would read, the Internal Affairs Division must investigate, in addition to any matter it is required to investigate by the chief or under department policy, any body-worn camera recording identified under subsection C or related to a complaint against an officer that, and then that involves, and then colon, a use of force, a child under the age of 18, a potential criminal offense with that clarifying language, a fatality or serious bodily injury or potential discrimination or harassment on the basis of race, ethnicity, or other protected class.
Okay. Chief, as it exists today, if there is a complaint given, does IAD come in immediately? Does someone else look at it and then they ask IAD to come in? How does it work in practice?
So in practice, all complaints, both internally and externally, are sent to Internal Affairs to be documented, at which point the Internal Affairs Director will make a determination based upon the severity of the complaint of whether or not the complaint is held as a formal investigation or an informal. And an informal complaint can be something which is much more of a minor type of complaint. For example, let's say someone calls and says a police car is parked in the fire lane, or a police car is speeding, and they provide us with the stock number of that police car. And therefore, that would be handled what we call at the lowest level. It would be handled by a supervisor, would be sent to the commander of that officer. The commanding officer then would give that to the supervisor to look into that matter and then to deal with the issue from a non-disciplinary standpoint, basically as a corrective measure, for example, or counseling for that particular officer, depending upon the amount of complaints that officer has received. And if there's a serious allegation, such as, let's say, use of force, all of those complaints are considered to be serious allegations. That will be a formal investigation by Internal Affairs Division, be investigated fully by an Internal Affairs investigator, at which point in time that process would come all the way with the final decision coming to a panel with the assistant chiefs and myself for disciplinary processes to be handled. So that at a basic level, that's really like to be clear, all complaints are documented, even at the lowest level, that are sent to Internal Affairs, are kept in a master log, and are tracked throughout its process to the end.
The suggested amendment that Ms. Wellens read for the first part, not the second part of it, but the first part. Are you comfortable with that or uncomfortable with that?
Well, I would say to some degree, for example, I think what she noted about that IAD would look at all of these complaints. I mean, my response to this is, for the most part, we already look at all complaints. It's not something that that's different. Clearly, that any complaint that comes in, we document, and it is already looked at. So I don't see a significant change from our policy, which we already do. I think the second part that she notes that I think Ms. Roberts clarified with Ms. Wellens is correct, is that if we get a complaint that has some criminal component to this, there's a criminal investigations that we feel that needs to be had, we refer that, I as the chief would refer that to an investigative body to be looked at, and looked at it and get a report back, but then in consultation with the state's attorney's office to make a determination of whether they would pursue that case criminally from that perspective. If the state's attorney's office agrees to take the case, then we allow that process to complete itself before an administrative review begins, which means that we would still, in any investigation such as this, we would still look at it from an administrative process. If the state's attorney's office declines prosecution from a criminal aspect, then we begin our administrative process investigation immediately there upon hearing that the state's attorney has declined prosecution in that regard.
Okay. Colleagues, where are you on this one? I think the second part obviously makes sense. I mean, we need to clarify it. My only concern is for the first part is the must, the word must, I guess, is what's been mentioned, that they must investigate. And I think that would be left up to some point for what they find out. I mean, if the way the system is working now, I think is a system that is working. So on that part. So that's where I am, but I'd like to hear from everybody else, please. Gentlemen. Vice President, President, please.
No, well, I'm sorry. Gabe looked like he wanted to get in.
He did, yeah.
No, I don't. Go ahead, Mr. President.
Oh, okay.
You just had that look, yeah.
Yeah, sorry. When you say, Mr. Chairman, that the current system is working, do you feel, I mean, on the East Silver Spring incident, what do you feel like?
It didn't. Well, the current system did not work at all on that one. So, right. But that system is when we found out about it, which was the problem.
Right.
And I think we're correcting that. And Ms. Wellens, Ms. Roberts, right. Please jump in here. But I think we're correcting that with the rest of this legislation. This is when IAD would get involved in it. Not when we'd find out about it, but when IAD would get involved in it, the way I'm understanding it. And I think that if it were, I mean, in this case, I mean, we shouldn't talk about a specific case, because this should be a general discussion. Sure. But in general, if there was a concern that a criminal matter had taken place, then the state's attorney needs to get involved with it very quickly. And in general, that doesn't always, it didn't happen. And we want it to happen sooner rather than later. Right. So yeah.
And he or she in the future would find out about the incident and the evidence much more quickly.
Yes.
That's, I think. Okay. Yeah, no, I agree with you. I think it's fine.
So not that we're going to talk about any specific issue, it's tough not to, but the fact that we're not going to talk about any specific issue, if there was a specific issue, just as an example, that someone thought that there could be that there was criminal possibilities, the way that this legislation is written, would we learn of it faster than what we've learned of it in the past? Can Ms. Wellens or Ms. Roberts or anybody be able to answer that question?
Yes, you're correct, Mr. Chair. The county executive and the county council would be required to learn of it earlier, but not only that, the state's attorney would be required to learn of it within 3 days. 3 days.
Which I think was the main concern of this whole issue. Yeah.
Right.
So if you're Vice President Albanaz, do you want to jump in on this one?
No, I agree with what you said, Mr. Chairman, and the president validated. I'm there too.
So Ms. Wellens, if you could write it so that as you have explained it, as I've tried to understand it, but if you have explained it on both parts, I think that would be the committee's recommendation.
Thank you, Mr. Chair. And I know, again, I apologize because it's kind of confusing to switch the language in real time. But so to clarify, we would say that IAD would have primary responsibility to investigate those matters as is reflected in the current policy. And we would make the clarification regarding that the IAD looks at potential administrative misconduct in connection with criminal offenses.
Yes. And please don't apologize. This has been, we wanted to get this done sooner rather than later. So therefore, when you do that, sometimes it doesn't always work in the perfect timeline. Okay. So number 3, please.
Yes, and you'll recall, Mr. Chair, number 3, we're at the bottom of page 8 of the staff memorandum. This relates to the issuance of body-worn cameras and the use of body-worn cameras by undercover officers. And as you'll recall, the committee asked staff to connect with the city of Gaithersburg to take a look at their policies and to also check in with the city attorney about their interpretation of the wiretap law. So I did confirm with Ms. Board, city attorney for the city of Gaithersburg, that their policy regarding the use of body-worn cameras by undercover officers, that they do integrate into that policy the requirements of the wiretap law, and specifically they specifically spell out the different provisions within their policy, including the requirements that the officer must, in order to use the body-worn camera to qualify for that exemption under the wiretap law, they have to be in uniform or prominently displaying a badge or other insignia. And what staff would suggest, Mr. Chair, is to simply make very explicit that the department must issue a body-worn camera for the use of an on-duty, uniformed, plainclothed, or undercover employee of the department whenever the employee is in uniform or prominently displays a badge or other insignia. I think that would hopefully at least in part, bring some clarity to the fact that an undercover officer, if they are falling within this criteria, need to be issued the body-worn camera for their use.
But to be clear, an undercover officer, while they are undercover, not in uniform and not in any way indicating they're a police officer, would not be wearing a body-worn camera.
Correct. They certainly would not be required to under this bill, but I would defer to the chief on whether that ever happens.
Yeah.
So
I mean, yeah, go ahead, Chief. You've actually done some undercover work. I have a feeling you wouldn't be sitting there with a camera. Yeah, go ahead.
I believe I shared this the last time we had this session, that I was vehemently opposed to our, quote, the definition of an undercover officer to wear a body-worn camera. There's a distinction here I want to make sure the committee understands, and Gaithersburg City has this in their general order. There's a difference between a plainclothes officer who has a different method of operation that we require, such as our special assignment team, which actually observes crimes in our districts, actually that are occurring in their presence, doing surveillance and maybe making an arrest of, for example, an armed robbery or a burglary or something of that nature. But that crime is occurring, and they're more of the street crimes unit that are observing crimes in real time, but they're plainclothes officers, versus an undercover officer who is posing in sort of the underworld, or the black market of narcotics, that are drug distribution, or playing some other role, posing as not a police officer, but playing in their role. And therefore, I would never want to provide confusion to when they don't wear a body-worn camera as an undercover officer. I agree that we need to work towards, and we've been working with the FOP in order to enhance our body-worn camera program, to have it to more units throughout the department, to include our plainclothes units. But I would suggest to this committee that this needs to be bargained based upon and I'll let Ms. Roberts maybe speak more specifically to this, that this is a bargainable issue with our union, that I really don't think it's a problem that we can get there for us to be able to put more body-worn cameras on our police officers, but there has to be those specifics that we need to work out in an agreement, as we have traditionally done with the body worn camera program period, to which officers are required to wear the body worn cameras and in what situations. So I would defer to Ms. Roberts, though, maybe to give more of that legal answer in this regard, to make sure I'm not missing a boat as it relates to our collective bargaining agreement with the FOP.
Yeah, just for clarification, the collective bargaining agreement itself does not contain the parameters of which units and which officers wear the body worn camera. However, our policy, our function code does specifically address those issues. And so historically, the way that we've made those changes is under the Article 61 of the collective bargaining agreement. We do, have to send the policy over to the union to discuss those. So we did have those conversations. We did not do full bargaining when we put cameras on the SWAT team, but we, you do have to have those conversations with the union. And so I think that under our current collective bargaining, the same conversations would need to occur if the department, the county was going to be expanding the units that currently would be wearing body cameras. There may be different types of cameras and that sort of thing.
Thank you. President Hawk.
Thank you, Mr. Chair. I thought the key word here in the language on line 23 and page 3 of the bill was just that the department must issue. The idea for this, and I don't think it's a philosophical one, because I don't think anybody wants to put an undercover officer in danger, and the intent was certainly not me as the sponsor, was to require that of an undercover officer while they're undercover, acting as an undercover officer. But what came up from talking to police officers in the union was that because of shift changes or whatever, an officer who might be undercover in the morning might be in uniform in the afternoon and has not been issued a body-worn camera. So then they're out there in uniform disclosing that they're a police officer, but they don't have access to a camera. So I think that was the only intent of this language, is just to make sure that there's a camera available for everybody that's in uniform or displaying a badge or other insignia, as the language says.
So I don't disagree, but what I still think we need to make sure that the language is clear. First of all, I would not put an officer who's working in an undercover capacity in uniform at any time while they're in an assignment of undercover.
Right.
But a plainclothes unit, there are times when we have operations that may require them to put on their uniforms to provide additional support for visibility. And I don't disagree with that. Again, that we would train them as well. And to make sure that they, while wearing uniform, they would be given access to a body-worn camera to be able to function while they are in that particular assignment. But again, we also want to make sure that make sure that this committee knows that I am in support of many of the plainclothes units in an operational time frame that they're actually going to make arrests or conduct search warrants, that they would be wearing body-worn cameras. And that's where we are trying to get to. Though I know this legislation is trying to make a point of that, but I'm just letting you know that we are already moving in that direction in order to make sure that, as Ms. Roberts noted, that we are going to notice the union to make sure. And I think they're in support of that, just as you noted, Mr. Hawker, by them saying that they want their officers wearing body-worn cameras when they're put in those types of assignments, such as being in uniform, and which I agree with.
Okay, Tom?
Yeah.
Vice President Albornoz.
Thanks. So just so I understand, so Chief, you're okay with the language that Ms. Wellens just articulated to avoid the issue that all of us agree we want to avoid of putting an officer at risk and potentially compromising their investigation if they are undercover. But the question now is whether this should be something that's bargained or not, or belongs in this policy at all. Is that where we are right now? That's a decision point.
So 2 points for me. the request I would have for Ms. Wellens is to change the terminology from undercover officers to plainclothes officers, because that's a difference. The undercovers are never put in a situation that we will put them in uniform. So therefore they would be out of this. My suggestion would for them to be out of this requirement. Plainclothes officers, yes. And that, yes, there is still going to be a requirement on our behalf, by the county's behalf, in order to at least notice the union, as Ms. Roberts has noted, about wanting to put these officers, to provide them with this equipment and train them with this equipment, and that they will be required by the policy to now wear this equipment in those types of situations where they're in uniform or in operations, as I have deemed necessary, as I noted earlier.
Okay. And I guess just to further illustrate this, so I'm in the council office building today and I'm looking outside, and I had flashbacks to there was an extremist right-wing rally on the steps of the council office building 2 years ago because of some positions that this council had taken on immigration issues. And several of us wanted to show strength and not fear. And we came and spoke at that event. But in order to ensure everyone's safety who was there, including the organizers on both sides of this event, there were plainclothes officers that were within the crowd just observing, making sure that they were among all of us to keep all of us safe. And in a situation like that, given that we aren't as far as we'd like to be with technology on these cameras, and what they look like and how clunky they are at the moment, the question would be, would we want an officer who's in a situation like that to have to, wear a camera that puts a big obvious marker on him or her being an officer? And so, which defeats the entire, and that's an example that's slightly different than the more obvious one, which is somebody who's involved in, an investigation involving, I don't even want to say it publicly just because, but I'm aware of investigations that have gone in the past years ago that help bring down certain criminal elements in our community. And those were deep-seated folks that were conducting those investigations. So there's a couple of, examples of that. I guess the other point to reiterate, as Chief Jones said, FOP has been pro-camera, very significantly so, as compared to other police unions across the country that have fought against this. They've actually been very active in trying to go beyond where we are as a community, which I think is a good sign of, a strong partnership and alliance there. But I think I got it. And I don't know if Ms. Wellens, you want to react to what Chief Jones said, or Mr. Chair. I feel comfortable with that, what Chief is proposing, just because I do think clarity here is important. But I just want to make sure we think through all of the consequences of that.
And I appreciate that. I think in this legislation, we certainly should not mention that it's something that the FOP would necessarily have to bargain. We would mention if they couldn't bargain it, but I don't know that we should mention that they should bargain it or that they have to bargain it. I think that we should leave the legislation as it is now, which doesn't say that would be something that's being bargained the way that I read it. But I also believe we need to make it clear that if someone is plain clothes and they, to the chief's example, if they're plain clothes and see something that is necessary for their immediate action, I mean, it may have never happened. They're in a restaurant, they're watching somebody, and somebody comes in and decides that they're going to rob that restaurant. That plainclothes officer is not going to have time to put on a body-worn camera. I mean, they're going to identify themselves as an officer. They're going to maybe put on a badge, but they're not going to be able to have time to put on a camera. And I don't want them to believe that they're in violation of something if they don't, because they had to act in the public's best interest immediately. Anymore, candidly, because there's so many cameras on the street with everybody with a phone, there's going to be people that are going to videotape the thing. But I don't want someone to believe that they can't do their job because they didn't have time to put on a body-worn camera. Any comment on that one?
Yeah, and I would just say, Council Member, Council Chair Katz, I mean, there are those situations that I think that there needs to be some leeway given. And though we provide direction in our policy and directives, but I think there are going to be some scenarios that could actually, you know, that would could put our folks in a different place, even though we would try to come up with different strategies to be more to have the cameras more accessible. And, you know, as technology changes, we will, of course, change with the technology when there's better equipment that might be better fit, that we know that for a fact, and maybe Assistant Chief Frank can speak to it better. But we know that, you know, that there are vendors that are coming out with more technology for plainclothes officers, more and more, that don't look as the same as the bulkiness of our patrol cameras that are pre-existing. Assistant Frank, can you comment on that to some degree?
Sure. We've actually engaged with Axon and given them guidance about some of the concerns we have producing, taking their platform and producing something that could be used by a plainclothes officer. So they have that information. We've also seen a couple other devices that we just had a demo, for example, on a camera that attaches to an officer's service weapon. For that type of use, it's a very interesting technology. And seeing how far it's come in the last 6 years has been really kind of amazing, because when I was first starting to look at the first pilot program for body-worn camera, it was a giant brick made by Panasonic with wires coming out of it, and it just in a short amount of time we've gotten where we are. So I think there's going to be options out there soon.
Well, you could say that for cell phones. Right. I mean, when cell phones first came out, the thing had to be on the bottom, have to have wheels on the bottom. It was this big, bulky. You could say that about a lot.
Remember the old bag phones?
The bag. That's exactly right. I mean, it was high tech in comparison to what we had, but it certainly wasn't going to be something that everybody used. So I think we're on the same wavelength here. I just think we have to figure out what's the best way to say it. And I guess maybe we need, in my scenario that I'm talking about, in the person in a restaurant, I think there needs to be a statement, if there's not already in there, that there's an exigency, a statement that says that, that there's a moment that we're not going to have, that you're not going to get in trouble by doing the right thing. I don't know how else to say it. So. Go ahead, President Hucker.
Mr. Chairman, it would have been my understanding, if this language were in place, that the plainclothes, non-undercover officer having breakfast in a restaurant would already be wearing a camera. Is that?
No, not if they're plain clothes. It would be if they were getting ready to make an arrest. And once they had identified, I believe I'm correct on this, once they identified themselves as a police officer and were going in to make an arrest, I mean, not an immediate type of.
Even if they're wearing a badge around their neck or something?
If they're wearing a badge around their neck, if they also had time to put the camera on.
But that,
I mean,
for example,
my concern is they wouldn't have time to put the camera on.
Right. So, Mr. Hucker, for clarification, if there are operations, there are times when those plainclothes officers are actually doing surveillance. That may be that require them to go out on foot. It might require them to go into a restaurant, fast food restaurant, in their capacity. But we would not want them to be identified as the police at that very moment, because they would be gathering some information or intelligence or observations of what is actually being seen out there. So under the term of where I'm getting at is, from an operational standpoint, when there is a strategic decision to make an arrest by a team in order to arrest individuals where, yes, we require them to have their identification, their badges showing so that they are identified and with other police insignia to make sure that people know that they are the police as they go in to make an arrest. Then that's when we would say absolutely we would want them to have their body-worn cameras activated in that role, but not like a patrol officer as they are patrolling the streets. Their cameras are always going to be attached to the officers in uniform. But if they're in plain clothes, there's going to be those selected moments that they would be required to have the camera activated.
Got it. Okay.
Ms. Wellens, can you do some, do you have your magic wand with you, Ms. Wellens? Can you?
Sure, Mr. Chair. So, I mean, I think going back to President Hucker's earlier point, I think the intent behind this language was to capture situations in which on an ad hoc basis, an officer who might normally be in plainclothes or different capacity where they're not, wearing uniform is called into service, for example, the January 6th riots, and is called into service and making sure that they have a body-worn camera in that scenario. So I guess, and based on the chief's comments, my staff suggestion would be maybe just either stick with the original language or indicate that, excuse me, let me look at the language more carefully. Okay, so to indicate that the department must issue a body-worn camera for the use of an on-duty employee of the department whenever the employee is in uniform. Might go to your concerns, Mr. Chair, about the plainclothes officer who's not wearing a big prominent camera. Sorry, thinking out loud here a little bit, but
we're prominently displaying. I thought there's two different things. Do they have a camera in their possession, in the trunk of the car or whatever, and do they have to wear it, right? And I thought the intention of the original language was just to make sure they had access to a camera so they could use it whenever the policy requires them to. This doesn't change the policy, right?
I think you are correct. Yeah.
The complaint I had heard is we have some officers that have to go into uniform, and then because they were in a different status, they didn't have access to a camera, but they want one.
Right. Right. And you're right, because those are the plain clothes officers that we did not, under the current policy, did not when we had the original body-worn camera program, they were not assigned cameras.
Right.
And so, yes. And then though they are still, even in our detective bureaus, our detectives are not assigned cameras, right? Because that's not their functionality. But there are times when we utilize, for example, when we have very large security details or, certain prevention details that we might have, we might utilize those officers to put them back in uniform for just maybe a day or 2 days. For example, when we have large inauguration events around the Washington, D.C. area, we do a security detail, and we'll provide additional officers, and we'll have to utilize those detectives. Well, we put them in uniform. So now I think what the FOP has stated to me, and I agree with them, is the fact that they want to be able to give those officers, and those officers want body-worn cameras, so when they are in uniform, and I'm fine with that. My only objection to this whole piece is I think the elimination of undercover officers needs to be eliminated. Mm-hmm. Outside of everybody else, I'm okay.
Okay.
Yeah, I think we all agree on that one.
Okay. We're all in agreement. Okay. Ms. Wellens, are you okay with what we've just determined?
Yes, thank you, Mr. Chair. So it's the language that's proposed here, but striking the undercover. So it would read, the department must issue a body-worn camera for the use of an on-duty, uniformed, or plainclothed employee of the department whenever the employee is in uniform or prominently displays a badge or other insignia.
Okay.
Okay.
Right.
Thank you, Mr. Chair. And the fourth issue for the committee's consideration, and we are on page 10 of the staff memorandum, relates to a suggestion by advocates. The Silver Spring Justice Coalition has suggested that officers with a history of misconduct should be subject to sort of a heightened review, should automatically have their body-worn cameras subject to a random review. So the staff concern here is that this might require, bargaining or a change to state law. But I'd also, if it's okay, Mr. Chair, I'd like to ask Ms. Roberts if she could talk about the current state law and the early intervention program, because I did not include that in the packet, but I think it's important for the committee to know about.
Sure. So Maryland state law and the public safety article, I believe, passed in 2016, a requirement for an early intervention warning system, if you will. So essentially that law in 2016 had a provision mandated that departments, if they receive 3 or more complaints against an officer, that they must then undergo this early intervention, looking at that officer for potential issues that may be involved with that officer. The most recent legislation, so pursuant to that state law, Montgomery County Police Department amended the policy. And so there is in place right now that early intervention where if there are 3 complaints that are received, IAAD has a tracking system. And so those 3 complaints, within a year for an officer, then IAAD will begin looking into whether or not there are bigger issues that need to be addressed. The department will look at that. The most recent legislative session appears to have, I think that the legislative intent was to specify both the prior law as well as, for instances, if an officer has 3 or more uses of force. So the way that it was written, it reads as if the only early intervention now is related to use of force. Montgomery County's policy, of course, remains compliant with what the prior terminology is. So right now in place for the department is the policy where if there are 3 or more complaints against an officer, obviously it will have to be updated to add in 3 or more uses of force, that triggers this early intervention. And so then that officer would be, the department would look at body camera or other incidents involving that officer. So that is the what current state law is. I don't know if that fully addresses the concern that the advocates had or not. I think that it addresses overall concerns. It may not be, they may not all be substantiated, but the law right now, as it reads, is 3 or more complaints. So I think it may actually potentially go beyond what the Silver Spring Justice Coalition had requested, but that at least is the current law and policy as exists in the department right now.
Well, I guess the question is, what is the definition of a history of misconduct? Because, I mean, if a history of misconduct is that it's somebody had 6 complaints, well, 3 or more obviously is already in existence. So I don't know what the word history of misconduct. It might be one of those deals, when you see it, but you can't define it exactly. And unless I'm missing something here, everything we're attempting to do is to make certain that our police force continues, because they're a very good police force. I want to stress that time and time again, but they continue to be a very good police force, and that there's not the concern that somebody would be doing something that's anything other than what we would want them to be doing as a police officer. So I think the way that this legislation is written right now does that. If it proves to be something different, or there's other discussions, then we should have those discussions. But at this point, I think we're doing what we tried to do with this legislation. President Hucker, you were one of the authors, the editors of this. Please correct me if you think I'm saying something that's incorrect.
No, I don't. I mean, we spent a lot of time with many different advocates on the language, and I mean, I think the proposed amendment's well intentioned. I just don't know how, to your point, how it conforms to our existing policy, how it addresses any due process concerns, and how that's defined. The question of history. Is a history one? Is a history two incidents? Is a history more than that? And what about the severity of the incident and the time period and all kinds of other things like that? I'm not trying to muddy the waters, but I think it's a valid concern about when these are reviewed, but it might be for another piece of legislation, because I think you'd have to address all those concerns rather than just adding an amendment right now.
Okay. Councilmember Vice President Albornoz.
Sorry, somebody's laying on their horn outside my window, so I had a hard time hearing some of that. But I guess, as everyone has stated, I certainly understand the premise from which the request was made. And I think that it sounds like already been an attempt to address it, because I would doubt that the chief and leadership would disagree that we want to especially monitor and keep tabs on officers when we know there are repeated issues of offenses, acknowledging there are a variety of ways that we're trying to address those issues and to ensure transparency. So, but it sounds like from Ms. Roberts' report out here that this is already addressed in a different way, and that there's really no need to refine it beyond what's already in there as it currently exists, as I understand it.
Okay. Is everybody, so unless I'm hearing different, then do we want to vote this out for 1821? Is there, I don't know, is there a motion? I think we can probably do it by acclamation. President
So moved.
Vice President Albornoz, are you going to second?
Second.
And we approve 1821 as amended. All those in favor, please raise your hand. And that is unanimous. So thank you very much. Anything else, Ms. Wellens?
No, thank you, Mr. Chair.
Thank you. Thank you all. We are adjourned.
Thank you all for your help with this and for your support.
Absolutely. We sincerely appreciate it.
Thank you.
Thank you. Have a good day.